Have you ever really stopped to think about what makes your online interactions, actually legal?
Hmm.
That email contract, maybe, or the thing you bought with just a click, or even how your data gets protected online.
Yeah, it's something we take for granted now, isn't it?
Totally. But these aren't just tech questions anymore. They're fundamental legal ones that prop up our whole digital life.
Absolutely.
So today we're doing a deep dive into the legal foundation for all of this, the Electronic Communications and Transactions Act of 2002, the ECT Act.
Right.
Our aim here is to really cut through the legal jargon, break down its purpose, the key bits, what it means in practice, making it clear for everyone, whether you're just curious about your digital rights or maybe even studying law.
And what's truly remarkable about this act, signed way back in 2002, is just how forward-thinking it was.
2002, it feels like a different era.
It really does.
Yeah.
But it essentially laid the groundwork for how South Africa navigates the whole information economy. It did that long before smartphones were everywhere. It basically turned these, intangible digital things to legally recognized actions. And it's not static either. It's been kept up to date. Last changes were December 2021, and it was reviewed again just this March 2025. So it's a living piece of law, adapting.
Okay, so if we boil it right down, what was Parliament really trying to achieve back then? What problem needed solving?
Well, at its core, the simple answer is facilitating and regulating electronic communications and transactions.
Right.
But the vision was much bigger than just rules. They saw the information economy was vital. So they aimed to promote universal access, especially getting digital services to underserved areas.
Okay, so bridging the digital divide was part of it from the start.
Exactly, and boosting the acceptance, the growth of e-transactions everywhere. The Act tried to knock down barriers to communicating electronically, building legal certainty, building confidence.
Confidence is key online, definitely.
For sure. Think about it. It encouraged e-government, pushed for high international standards, aimed for a secure online space for consumers, for businesses, for government itself.
Right.
And it wasn't just regulation, it was strategic support too. Developing digital skills, boosting SMMEs in the electronic space, managing our national online identity, the .zo domain.
The .zo domain.
And it was about building a whole digital society, not just tweaking a few tech rules.
That's a huge scope for an act from 2002. It really does sound like setting the stage.
Yeah.
But okay, let's unpack this sphere of application idea. Does it cover every single electronic thing you do?
Yeah.
And does it, force us to use email instead of paper?
That's a really important point. So the Act applies to basically any electronic transaction or data message.
Data message.
Yeah, this is legal speak for any info generated, sent, received, or stored electronically, like an email, a text, maybe even a voice note in some automated systems. It gives them legal standing.
Okay.
But, and this is crucial, it explicitly says it does not require anyone to use electronic forms. You can still stick to paper if you want.
So no forcing digitalization.
Nope. And people or companies can still set their own rules for how they accept data messages. But what's really key are the specific exclusions. The Act doesn't apply to certain parts of wills. Selling land, alienation of land is the term, bills of exchange, and stamp duties. Those are listed out in Schedules 1 and 2.
So for really big things like buying a house or signing your will, a digital signature just won't cut it.
Precisely. And the thinking there is, while the Act embraces digital efficiency, it respects the existing, very formal legal requirements for these high-stakes transactions.
Makes sense.
Things like property deals, long leases, wills, they have huge legal and personal weight, right? So the law keeps the need for traditional paper and, wet signatures to ensure maximum certainty and avoid disputes. It's a balance. Innovation meets critical legal tradition.
Okay, that makes sense. Now here's where it gets really interesting for me. How does the Act actually give legal power to a digital message? What is it that makes an email as valid as paper? How does the law make that jump?
All right, this is the engine room, Chapter 3, Facilitating Electronic Transactions. Section 11 is absolutely foundational. It's not just words. It legitimizes our digital interactions. It says information isn't denied legal force just because it's in the form of a data message.
So without that section, my online bank statement might mean nothing legally.
Potentially, yes.
Yeah.
Or an email contract, even a WhatsApp, confirming a deal. It's the quiet enabler. And it goes further. Even info linked within a data message, like a hyperlink to terms, carries legal weight if it's clearly referenced and you can actually access it.
So that tiny link to the TNCs could be binding, as long as I can click it and read it.
Absolutely. Then you have Section 12. If a law says something needs to be in writing, That's met if it's a data message and you can access it later for reference,
Yeah.
like saving an email.
Okay.
And Section 13 tackles signatures, which can be confusing. If a law requires a signature but doesn't say what kind, then you need an advanced electronic signature.
Advanced. What makes it advanced?
Good question. It's not just scribbling on a screen. It's a specific type of electronic signature that's been officially accredited by an accreditation authority. Think of it like a high-security digital stamp, verified by a trusted body. It offers the highest assurance.
So it's like a certified digital signature.
Pretty much. However, an ordinary electronic signature, which is just data attached to other data, meant by the user to be a signature, is still legally valid in many cases. If people agree to use an e-signature but don't specify the type, it's okay if it identifies the person, shows they approved, and was, quote, as reliable as was appropriate for that situation.
Okay, that distinction between electronic and advanced electronic signature seems really important. It's not just semantics.
Not at all. And because they're accredited, advanced electronic signatures are legally presumed to be valid. Section 14 covers the idea of an original document. A data message counts as original if its integrity is solid, it's complete, unaltered, apart from normal things like adding an endorsement and you can display it.
So the digital version has to be authentic.
Right. Section 15 is about court. Data messages are admissible as evidence, and courts must give them due evidential weight, looking at how reliably they were generated, stored, and who sent them. A data message made in the normal course of business, that's even considered rebuttable proof.
Rebuttable proof, meaning it's taken as true unless someone proves otherwise.
Exactly, which is a big deal for digital records. Your digital invoices, bank statements, they carry real weight.
That's a massive shift from a paper-only mindset.
It is. Section 16 says storing info electronically is fine if it's accessible, accurate, and you can tell the origin, destination, and time. Now here's something very relevant day to day. Automated transactions. Section 20.
Like booking flights online or using chatbots.
Precisely. It deals with agreements made by electronic agents, basically computer programs or automated systems.
Oh.
If you use one, you're generally bound by the agreement even if you didn't review every step the agent took.
Oh, okay.
Unless the terms weren't actually reviewable by a person before you finalize the deal.
So if I buy something from an automated system, I'm stuck with it. But if they hid the terms until after I clicked buy, maybe not.
That's the idea. And there's another protection. If you, a person, make a significant error interacting with an automated agent, and the system didn't give you a chance to correct it, and you notify them quickly, take steps to return any benefit, and haven't actually benefited yet, then no agreement is formed.
Ah, so there's an oops clause for genuine mistakes with machines.
You could call it that. It ensures some fairness with automation.
Mm.
So yes, your online banking, that e-contract signed with an advanced signature, it has real legal force, provided those conditions on reliability and identity are met.
That really does give digital interactions solid legal standing. Now, what about the practical side, the nitty-gritty of when and where an online agreement actually happens? Does it matter if I'm here and the website server is somewhere else entirely?
Oh, it absolutely matters, especially if there's a dispute later about which court has jurisdiction. Section 22 says an agreement isn't invalid just because it was done electronically.
Oh.
And critically, an agreement made with data messages is considered concluded, finalized, when and where the acceptance of the offer was received by the person who made the offer.
Received, not sent. That's key.
Very key. Section 23 clarifies timing and location further. A message is sent when it leaves the sender's control. It's received when it enters the recipient's designated system and they can actually retrieve and process it.
And the where.
Generally, it's considered sent from the sender's usual place of business or residence and received at the recipient's usual place of business or residence. This brings much-needed certainty to borderless digital deals.
Right, that clears up a lot. Now, moving beyond just individual deals, the Act seems to have this broader vision for the country's digital future. How does it push for wider digital use and protect our collective interests?
That's exactly right. It's about building the whole digital ecosystem. Chapter 2 is all about the national e-strategy. It actually required the Minister of Communications to develop a 3-year national plan approved by Cabinet, making digital progress a national priority.
A concrete plan, not just vague ideas.
Exactly. And it wasn't just talk. It outlined actual programs for universal access, getting internet to disadvantaged communities, raising public awareness. It aimed to empower previously disadvantaged groups and SMMEs through things like community e-centers, and focused on developing IT skills.
So the government wasn't just reacting to tech, it was trying to shape a more inclusive digital future.
That's the insight, yes.
Yeah.
Proactive shaping, not just passive regulation.
And did it push the government itself to go digital, walk the talk, so to speak?
It certainly did. Chapter 4 covers e-government services.
Yeah.
Sections 27 and 28 explicitly allow public bodies, government departments, municipalities to accept electronic filings, issue permits or licenses digitally, and handle payments electronically.
Even if other older laws didn't specifically mention digital methods?
Exactly. It effectively overrides those older limitations, clearing the path for digital transformation in public services. Government bodies can also specify requirements, like needing a certain type of e-signature or preferring specific trusted authentication providers like the post office to ensure security.
Makes sense for efficiency. But what about us, the average person shopping online? What concrete protections are built in for consumers?
That's Chapter 7, Consumer Protection in Electronic Transactions. Hugely important for building trust. Section 43 lays down strict rules for suppliers. They have to provide a ton of clear info on their website.
Like what kind of info?
Their full legal name, physical address, email, registration details, clear product descriptions, the full price including all costs, no hidden fees, payment options, delivery times, return policies, their payment security measures, privacy policy.
Wow, quite a list.
It is. And crucially, before you place the final order, you, the consumer, must have a clear chance to review the whole transaction, correct any mistakes, and back out if you want to.
So a final sanity check before committing.
Right. And suppliers are liable if their payment system isn't secure and you suffer damages because of it.
And what about that cooling off period you hear about sometimes? Can I just change my mind after buying online?
Ah, yes. Section 44, that's a major protection. For most goods bought online, you can cancel the transaction without giving any reason and without penalty within 7 days of receiving the goods.
7 days, okay.
For services, it's 7 days from concluding the agreement. The only cost you might have to cover is the direct cost of sending the goods back. If you paid already, you get a full refund within 30 days of canceling.
That really builds confidence, doesn't it? Knowing you have that safety net.
It absolutely does. It's about building systemic trust. When consumers feel safe, the whole digital economy benefits. But it's important to know the exceptions in Section 42. The cooling-off period doesn't apply to things like financial services, auctions, food that perishes quickly, custom-made goods, open software or media, newspapers, gambling, or specific date-based services like flights or accommodation.
Okay, good to know the limits too. So consumer rights are covered, but trust also depends on the security tech itself, right? Encryption and things like that. How does the Act handle those tools?
Good point. Chapters V and Z, I tackle that, focusing on cryptography providers and authentication service providers. This is about building trust in the underlying tech infrastructure.
Cryptography, like making data unreadable without a key.
Exactly. Chapter 5 says anyone providing those kinds of services in South Africa needs to register with the department. Interestingly, they don't have to reveal trade secrets during registration. It's about oversight, knowing who the players are without killing innovation. Failing to register is an offense.
So transparency about who provides security, but not necessarily how they do it unless legally required.
Precisely. Then Chapter 6 deals with authentication service providers and the whole accreditation process we touched on earlier with advanced signatures.
Right, the high security digital stamps.
Exactly. The Director General acts as the accreditation authority. Accreditation is voluntary, but if you want your advanced electronic signatures to have that legal presumption of validity, you need it.
And the standards are high.
Very high. The signature tech must be uniquely linked to the user, able to identify them, created under their sole control, and linked to the data so any changes are obvious. It even specifies face-to-face ID checks for the user initially. The insight here is how the Act builds trust layer by layer, regulating the tools that secure data and prove identity online.
It really sounds like a carefully constructed system for digital trust. What about protecting really big, important data sets, national level stuff?
That's covered in Chapter 9, Protection of Critical Databases. The minister can designate certain data as critical, vital for national security or the country's economic or social well-being.
Like infrastructure data, maybe?
Could be, yes. The Act allows identifying specific critical databases. The administrators of these databases have to register them and follow strict standards for management, access control, data integrity, disaster recovery plans. It's about safeguarding core national digital assets.
And just on a more everyday level, our online identity,
Right.
those website addresses ending in .sati, who manages those?
That's Chapter X, a data domain name authority and administration. It actually established a specific legal body, the Date Domain Name Authority.
Oh, wow. Okay.
Their job is to manage South Africa's entire .sati domain namespace. Think of them as the official guardians of our national online identity. They license the companies that register domain names, registrars and registries, make sure we follow international best practices, and handle things like pricing policies and dispute resolution.
So if two people want the same .sa website name, there's a process.
Yes, there are alternative dispute resolution mechanisms specifically for .sati domain name fights. It ensures fairness in allocating that digital real estate.
Okay, so we have all these rules, protections, authorities, but who actually enforces it? What happens if someone breaks the rules online? Who holds them accountable?
Right, enforcement. Chapter 11 deals with something important. Limitation of liability of service providers.
Service providers, like my internet company or the platform hosting a website.
Exactly. Anyone providing information system services. This chapter sets out conditions where these providers are not liable for illegal stuff their users do. For instance, if they're just a mere conduit.
Just passing data along.
Yes, just transmitting data without changing it or choosing who gets it, they generally aren't liable for the content. Similar protections exist for caching or hosting content, provided they don't know about the illegal activity and act quickly to take it down if they get a proper takedown notification.
So the platform hosting an illegal post isn't automatically guilty, but they must act if someone officially tells them about it. That sounds like a balancing act.
It's a critical balancing act, trying to protect free expression and information access while still fighting online harm. Section 77 details the takedown notice procedure. Importantly, service providers generally have no general obligation to monitor everything users post or send. They don't have to actively hunt for illegal activity.
But a court could order them to stop something specific.
Yes, a court can order them to terminate or prevent unlawful activity.
And who are the boots on the ground, the sort of digital police making sure rules are followed?
That would be the cyber inspectors set up under Chapter 12. They're appointed by the Director General of Communications.
And what can they do?
Their powers in Section 81 are quite broad. They can monitor websites for compliance, investigate cryptography and authentication providers, issue compliance orders, and audit those critical databases we talked about.
Can they search premises or computers?
Yes, but under strict conditions. Sections 82 and 83 give them search and seizure powers, but they need a warrant from a magistrate or judge, following the principles of the Criminal Procedure Act. With a warrant, they can enter premises, access systems, copy data, demand technical help, but they have a duty of confidentiality. Obstructing them, or pretending to be one, is an offense.
So real investigative powers, but with legal oversight. What happens if someone is actually found guilty of breaking these ECT Act rules?
Chapter 13, Section 89 covers penalties. For the specific offenses created by this act, like falsely claiming accreditation, non-compliance by critical database admins, obstructing inspectors, the penalty can be a fine or up to 12 months in prison.
Okay.
It's important to note, though, that many of the original cybercrime sections that were in the ECT Act have since been repealed and are now handled by newer, more specific laws, like the Cybercrimes Act 19 of 2020.
So the law evolved, and specific cybercrime is dealt with elsewhere now mostly.
Correct. And finally, Chapter 14 clarifies jurisdiction. It lays out when South African courts can handle offenses under this act. Basically, if the offense happened here, had an effect here, or was committed by a South African citizen or resident, even if they were overseas, it stops digital offenses slipping through jurisdictional cracks.
Wow. What a truly comprehensive journey that was. From just sending an email to managing national digital infrastructure and protecting online shoppers, the ECT Act really does underpin so much of our digital world.
It really does.
It's quite amazing how the law evolves, trying to keep pace with technology, building this framework for trust and order online.
And this deep dive really highlights a fundamental challenge, doesn't it? How do legal systems provide certainty and protection in such a fast-changing tech landscape without accidentally choking off innovation?
Yeah, that's the tightrope.
This act gives us a solid foundation, established back in 2002. But think about today: AI, quantum computing, the metaverse.
Yeah.
These things constantly test how adaptable laws like this are. It makes you think about your own digital life, doesn't it? How this invisible legal structure protects and regulates you every day. The question really becomes, what new digital frontiers are emerging right now that will demand the next major legal deep dive? That's something to really ponder as our digital future keeps accelerating.